Hello and welcome to 100th edition of Strive Dialogue. It's a very proud movement for us that today we have completed 100 episodes. And another very special event as on today is that we've had army officers, air force officers, we've had officers and people from the think tank. Today we have a very special guest with us, Mr. Puneet Chaturvedi, who has joined us to give us the legal aspects of the recently concluded Article 370 decision by the Supreme Court. For due to some technical reasons, we cannot see him on the stage, but his audio is loud and clear. Mr. Puneet Chaturvedi, welcome, sir. Sir, can you hear us, sir?
I can listen to you very cleanly.
Yes, sir. Now we can hear you, sir. Welcome to the show, sir.
Thank you so much.
Before we proceed, sir, I would like to give a brief introduction, which is in brief but quite a mouthful. Shri Puneet Chaturvedi belongs to family of lawyers for 4 generations, having associate law offices across India. He has been practicing as an arguing counsel for last 34 years and appearing in the Supreme Court of India as well as at various high courts across India besides practicing in Bombay High Court. He has taught law in University of Mumbai and in Government Law College Churchgate, Mumbai, and has been regularly invited by various other law colleges. He also writes legal articles and columns in magazines and websites. His article and speeches are widely hailed. Shri Puneet Chaturvedi has also been addressing the annual law training and lecture series conducted by the Bar Council of Maharashtra and Goa on the Constitution of India. He provides free legal aid and argued several public interest litigations. He has addressed different medical forums on medico-legal topics. He has been addressing and enlightened several professional forum, institutions, colleges, corporate houses, bar association on varied subjects of law. Interestingly, his talks are attended by a judiciary also. Shri Puneet Chaturvedi has also been appearing as a law expert in the property show in on NDTV and is invited by different television channels on to speak on various legal topics. Interestingly, Shri Puneet Chaturvedi is also a noted scholar of the ancient Indian scriptures like Ved Vedant, Upanishads, Puran, Bhagavad Gita, Ramayana, etc., and has developed extremely lucid and pragmatic application driving from Ved Vedanta. His discourse on the logical interpretation of Ved Vedanta, Bhagavad Gita, Ramayana, and other ancient scriptures are organized across India and abroad. He has conducted Vedantic workshops in schools and colleges, management institutions, corporate houses, chambers of commerce, jails, clubs, courts. He also writes articles on Vedantic principles. He is ably assisted by his wife Srimati Rashmi Chaturvedi. In order to listen the talks of Mr. Puneet Chaturvedi on various topics of law as well as on Ved Vedant, one can visit YouTube by simply searching Puneet Chaturvedi Advocate. Sir, that was impressive.
Thank you so much.
Sir, first of all, thank you very much for joining us, sir. Like I said, this is the first time we have an advocate from the Supreme Court who has joined us live. And now we will start with the discussion, sir. As you are aware, recently Kashmir will remain an integral part of India. This is what the Supreme Court has said. Now, various legal luminaries have commented on this. Fali Nariman, in an interview to The Wire, has said that the judgment constitutionally flawed, bad in law. Ram Vadhav, on the other hand, feels for the sake of union. He says the verdict goes by letter and spirit of constitution. Similarly, Anuradha Bhasin has also written an article where she says the Supreme Court's verdict on Article 370 brushes aside both legality and history. She says the court set a dangerous precedence in the Article 370 case by endorsing the legal jugglery that broke the promise between union and the state. In Pakistan, Sadir Hussain writes the aftermath of India repealing Kashmir's status, and he has gone on to the extent to say that it will have serious socio-political ramifications on India. Sir, I will request you to clear this web which has been created for us to initially tell us what are the legalities and then we proceed with the discussion. The stage is yours, sir.
Thank you so much. Now let's begin with the legality aspect first, because most of you are already aware about the historical background of Kashmir. So I will begin with the specific method by which the government of India revoked and abrogated Article 370, and then we will go back in the flashback of a slight history as to how it was introduced. On 19th June 2018, BJP withdrew its support from PDP government in Kashmir. As soon as the support was withdrawn, the then governor of Jammu and Kashmir, under section 92 of the Jammu and Kashmir Constitution, invoked the governor's rule there. Now, this is within a day, 19th June 2018, the support was withdrawn. 20th June, governor rule under section 92 of Jammu and Kashmir Constitution was applied. Now, 5 months later, on 21st December 2018, 21st November 2018, the governor dissolves the Legislative Assembly. Now, please understand over here the legality. Support was withdrawn in June. Governor rule under section 92 of the Jammu and Kashmir Constitution was imposed on 20th June 2018. 5 months down the line, the governor dissolves the Legislative Assembly of Jammu and Kashmir on 21st November 2018. After the dissolution of the House, on 28th November, the governor sends a recommendation to the President of India that House has been dissolved, and that recommendation was to apply the President's rule under Article 356 of the Constitution of India. Now, please understand, the governor's rule was under section 92 of Jammu and Kashmir Constitution. Whereas now on 28th December, the President's rule begins under Article 356 of the Constitution of
He is
India.
not possible. Yes, yes, that accept.
Now,
problem.
on 28th November, this recommendation was sent, and on 19th December 2018, please remember, 19th December 2018, the President proclaimed Article 356 of the Constitution of India. The President rule in Jammu and Kashmir begins. Now, by this proclamation under Article 356 of the Constitution of India, 3 things had happened. In that proclamation, the President declared 3 things. First, that the powers of the governor are assumed by the President of India. The second, the powers of the Legislative Assembly are assumed by the Parliament of India. So the Legislative Assembly's powers, Legislative Assembly of Jammu and Kashmir, those powers are transferred to Parliament of India. And third, Article 3 was suspended, which had an exception of Jammu and Kashmir. So these three things happened in the proclamation dated 19 December 2018 by the President of India. This proclamation of 19th December 2018, as per the mandate of the Constitution of India, was approved by the Lok Sabha on 28th December 2018. And on 3rd January 2019, the Rajya Sabha also approves this proclamation of President's rule in the Jammu and Kashmir. Now, please remember, we are at the end of 2018, and on 3rd January 2019, Rajya Sabha also approves this proclamation. So we are at beginning of 2019, 3rd January. Now, as we all know, that the President's rule as per the mandate of the Constitution of India can remain only for 6 months. So, on 28th June 2019 and on 1st July 2019, Lok Sabha and Rajya Sabha grants extension of the President's rules for further 6 months. So now again, we are in the mid of 2019 and the President's rule extension has been given to the end of 2019. But immediately within a month, on 5th August 2019, as soon as the President's rule is extended in July, 5th August 2019, the President of India issues a Constitution Order number 272 of 2019. Now, this constitutional order is application to Jammu and Kashmir. Now, by this order, constitutional order, the President of India does two things. First, all the provisions of the Constitution of India henceforth are applicable to Jammu and Kashmir. That is the first thing in this Constitution Order of 272. The second thing in the Constitution Order of 272 was that a subclause 4 was added under Article 367. By that, now I will just explain that what had transpired. Article 367, a subclause is added where it has been said that as far as Jammu and Kashmir is concerned, the President of India is empowered to add on the recommendation of the Legislative Assembly. And this, on the basis of this insertion of subclause 4 into 367, 370 subclause 3, which had given the power to the President of India to make any changes in Jammu and Kashmir or in respect of Jammu and Kashmir, and cancel Article 370, provided on the recommendation of the Constituent Assembly of Jammu and Kashmir. Now, this was the biggest hiccup because Constituent Assembly was dissolved in the year 1957. So there was no Constituent Assembly. So who will recommend? And it was considered all through that the President of India is handicapped. In the absence of any recommendation by the Constituent Assembly of Jammu and Kashmir, the President of India cannot revoke Article 370. But what maverick activity had happened by the government, that by bringing insertion of subclause 4 into Article 367, they made a change into subclause 3, and the Constituent Assembly was replaced by the word Legislative Assembly. Now, please understand, the moment the word Constituent Assembly is replaced by the word Legislative Assembly, and that means the government of Jammu and Kashmir has to recommend, what had happened by the president's rule, I had explained you three things in the president's rule when it was applied on 19th December 2018. Three things had happened. The governor's power assumed by president, the legislative power of the Legislative Assembly of Jammu and Kashmir was assumed by the Parliament of India. So therefore, that hiccup of recommendation from the Constituent Assembly is replaced by the Government of Kashmir. And the Government of Kashmir, that means Legislative Assembly of Jammu and Kashmir. And the Legislative Assembly's power were assumed by Parliament of India. And therefore, it was only on the Parliaments of India recommendation the President can abrogate Article 370. So it was a kind of maverick wizardry onto these provisions. And therefore, on 5th August 2019, the Rajya Sabha recommended to the President of India that all the clauses of Article 370 except clause 1 are to have a cease to have effect. On the basis of this recommendation made to the President of India, the abrogation of Article 370, that recommendation part, that path was clear, and the President declared and sent Constitution Order 272 as well as Constitution Order 273.
Yes.
That is reorganization of the state of Jammu and Kashmir. And the moment these two constitution orders were passed, first was on the recommendation of the Parliament and the second was sent back by the President to the Parliament, which the Parliament first accepted, and then on 6th August 2019, Rajya Sabha as well as Lok Sabha passed the Constitution Order 273 for the reorganization of the state of Jammu and Kashmir into two union territories, Union Territory of Jammu and Kashmir and Union Territory of Ladakh. On 9th August 2019, when the path was clear and these two declarations, proclamation had come into the light, the Home Minister of India, Amit Shah, in the House of the Parliament, on 9th August 2019, issued a notification that the reorganization of the state of Jammu and Kashmir into two union territories shall come into effect with effect from 31st October 2019. And on 31st October 2019, by the coming into effect of those company orders, the state of Jammu and Kashmir was divided into two union territories and the President rule ceases. It is to revoked. Now, this is the chronology of the way abrogation of Article 370 happened. Now, coming back to those who are commenting as to this is bad in law or that has bad in taste, according to me, what Mr. Nariman has been commenting is to be understood more than what the Pakistani journalists have been doing, because they are doing it with obvious reasons. What we have to understand why Nariman Saab has been saying this, because he is our legal luminary. And Fali Nariman said that Article 370 judgment is constitutionally flawed and bad in law because, according to Fali Nariman, instead of going by the way of Article 367, inserting subclause 4 there, why the government of India has not taken the path of Article 368 of the Constitution of India? Because Article 368 gives the Parliament of India the power to amend the Constitution of India. But with due respect to Mr. Fali Nariman, I differ with his point of view. I differ on the point of view because if you go by the path of Article 368, amend the Constitution of India, and try to amend Article 370, the point of the recommendation of Constituent Assembly still remains, because you can't go back to the Constituent Assembly of Jammu and Kashmir. The only method remained was to go Article 367, insert a clause there, on the basis of that, amend Article 370, subclause 3, and that is what had been done. So according to me, it was a draftsman wizardry. It was a maverick activity by the government of India, because if you remember, there was a time when Prime Minister Narasimha Rao had said that we can't afford to abrogate Article 370. The moment we do, we will lose Jammu and Kashmir. So this was the idea floated all through by various governments, and still going ahead and doing it and getting ratified by Supreme Court of India is not an easy task. So the prophets of doom of Pakistan may say whatever they want to say. I give more respect to Fali Nariman being a constitutional expert, but with a due respect to him, I differ with his point of view, and I cannot endorse that Article 368 things could have been done, because he, being a devout constitutional lawyer, wanted things to happen according to Article 368 and amend the Constitution. But that could have also, the government of India at that time could have also faced another problem if they had taken the path of Article 368, because then you have to have two-thirds of the majority in the parliament to approve it, and that too into Rajya Sabha, which the then government did not have. And if you want to amend the Constitution of India to amend it in respect of states, you have to have the concurrence of the states as well. So that path would have been extremely difficult, and the chances of failure was more. Now, coming back as to how this Article 370 has come into picture in the Constitution of India. Now, why I say that this is a maverick activity, and I differ with the opinion of Fali Nariman, because primarily, if you see the judgment of the Supreme Court of India, it has been discussed at length. My point of view after going through the judgment is that the instrument of accession was signed by the ruler of Jammu and Kashmir way back on 26th October 1947. Now, please remember this date and understand why I am making this comment. Now, if an instrument of accession is signed on 26th October 1947, the Constitution of India was nowhere in picture.
Absolutely.
Neither the Constitution of Jammu and Kashmir was in picture, because Jammu and Kashmir Constituent Assembly was formed in 1951.
Correct.
Now, this instrument of accession by Maharaja was unconditional, but it has a covering letter by Lord Mountbatten,
Yes.
who had inserted a condition that we are taking your instrument of accession, but as soon as the situations normalize, we will try to get the opinion of the public of Jammu and Kashmir. That was foolish. And why he did so, maybe because of the their own interest. And unfortunately, our leadership at that time was blindly supporting Lord Mountbatten and had a full trust and given him the free go. It was because of that letter. This has been said that there was this instrument of accession by Maharaja Hari Singh was conditional, and paragraph 7 in the instrument of accession was added. Now, if you read the paragraph 7 of instrument of accession, there certain conditions were added. But still, despite that clause being there, and despite the letter of Lord Mountbatten was there, in my opinion, this was all happened in the year 1947. Thereafter, on 5th March 1948, Maharaja Hari Singh issued a proclamation for formation of the Constituent Assembly of Jammu and Kashmir. Now, please understand, if the instrument of accession is signed in the year 1947, the sovereignty of Jammu and Kashmir undoubtedly was surrendered by Maharaja Hari Singh to the government of India.
Correct.
Now, if a person does not remain a sovereign head of a geographical area, under which power could he issue a proclamation of formation of Constituent Assembly? In the instrument of accession, no such power was given to Maharaja Hari Singh despite Mountbatten's efforts, because nobody denies that instrument of accession was signed. Now, what remains was that if you see the integration of states, other states in India, there were two instruments signed. First was the instrument of accession, and later the instrument of merger. Now, what the Jammu and Kashmir petitioners had been trying to propagate is that the instrument of merger was never signed because of Lord Mountbatten's letter that we will first ascertain the views of the public of Jammu and Kashmir. But notwithstanding the instrument of merger, when the accession is there, the sovereignty aspect is over. What remains till the instrument of merger is signed is the autonomy of the state, other than the three areas of defense, communications, and one more,
Foreign affairs.
foreign affairs. So there is a difference between sovereignty and autonomy. Now, if the sovereignty has been surrendered, all succeeding activity by Maharaja Hari Singh has no legal sanctity. So the very formation of the Constituent Assembly of Jammu and Kashmir, according to my humble opinion, does not have a legal sanctity. Because if you remember, the Constituent Assembly of the Government of India, or the Constituent Assembly of India, was formed on the proposal of Cabinet Mission of 1946. Cabinet Mission had deliberated, and the first plan which was submitted by Cabinet Mission was to have adult suffrage. Representative elected for the Constituent Assembly should be through adult suffrage. But when it was realized that that will take huge amount of time to first create a voter list, and that time India was not in this form as it is in today. It was divided into three territories: British provinces, princely states, and the foreign occupation of France and Portugal and all that. So electing representatives on electoral basis and adult suffrage was next to impossibility. So therefore, the cabinet mission suggestions and advice were modified, and the then interim government of the British provinces were allowed to have their representatives on the basis of the proportional representation of 10 lakh persons. One person should be sent to Constituent Assembly, and so were the princely states given the authority to nominate persons to add into the Constituent Assembly. No such exercise had happened for the formation of the Constituent Assembly of Jammu and Kashmir. So neither the Constituent Assembly of Jammu and Kashmir was democratically elected. Who elected those representatives into the Constituent Assembly, nobody knows. And nor the formation of Constituent Assembly was by any sanctity of the sovereign authority. Because if you remember, the cabinet mission plan was backed by the resolution passed by the British Parliament, who had sent the cabinet mission to India with a view to explore the possibility of forming a Constituent Assembly. So that was with the backing of a sovereign authority. So please understand, in the legality of these aspects, in my humble opinion, Maharaja Hari Singh did not have any sovereign authority to constitute or proclaim the constitution. Then it is important to understand that once the draft Constitution of India was finalized by the drafting committee under the chairmanship of Dr. B.R. Ambedkar, it is a matter of record that this draft constitution was published widely across India. In fact, at that time, the copy of the draft constitution was sold at ₹1 per rupee to whoever wants, who could not have an access to the publication. He wants to purchase the draft, he could purchase it, and the recommendations, comments were invited from the public at large. So though adult suffrage was not there, still that opportunity to the public at large was given before finalizing the Constitution of India. These are historical facts. And that is why the Constitution of India has a proper legal sanctity vis-a-vis Constitution of Jammu and Kashmir. What the Supreme Court has come to the conclusion in this judgment, that the petitioners were trying to propagate that as soon as the Constituent Assembly is dissolved, the temporary provision of Article 370 got permanence. But the Supreme Court did not agree with this falsity, because the Supreme Court said that nothing can be permanent, and the Constitution, wherever in the world, having read multiple constitutions of the world, I can say with authority that the Constitution normally are a living document. Unlike the religious texts, which cannot be amended. Religious texts have a dogma that whatever is written is written. We are fortunate into Sanatan Sanskriti, because I have been reading a lot of Upanishads and Shastra and Ved. So I can say that that beauty of amendability is still there in our scriptures. We had the method of Shastrarth, where we were allowed to discuss, debate on every shlok, every provision, and that could be stand corrected. And similarly, the Constitution of India, if a word Constituent Assembly is inserted, does not mean that in the changed circumstances that becomes like a dogma that nothing can happen. So one can always go back and into the circumstances, looking to the circumstances of the situation, things can change. And it had been the norm across the world. Therefore, if you remember, even historically, the very history of Kashmir has been changed multiple times. Originally, it was a Sanatan dominated area. Later on, it came under Muslim rule. And in the year 1834, the army general of Raja Gulab Singh attacked this area and included Ladakh into the territory. And therefore, Gulab Singh became the king of that area. And there was also a war historically in 1841 and 42 between Sikhs and China, where Chinese forces were defeated by Sikhs. And immediately thereafter, there has been a Lahore Treaty between the Maharaja of the Punjab and the Britishers in 1846. After that Lahore Treaty, this entire area was under these Dogra kings, were handed over by this Lahore Treaty. And in 1857, Gulab Singh died and his son Ranbir Singh took over. Ranbir Singh's son in 1885, Pratap Singh became the king, and 1925, Raja Hari Singh came into the picture. Now, it is very unfortunate that Raja Hari Singh had this lopsided, when the changing stance kind of view. He did not have a clarity of mind, and he went into the dreams that he could remain independent despite not merging either into dominion of Pakistan or dominion of India. But that had created all problem, and immediately thereafter these tribal attack had happened, and then he sent SOS to the government of India to send military, and it was rest all military activity. You all know better than me, so I need not to go into that. But what I want to inform you all is that by the accession treaty, one more incident also happened. There was a proclamation of 25th November 1949,
Right.
where Maharaja, that Yuvraj Karan Singh, had surrendered this absolute power to the government of India. And that was prior to the promulgation of the Constitution of India.
Right.
And Constitution of India was promulgated on 26 January 1950 with Article 1 into it. Now, it is very important to note what is Article 1. Article 1 read with Schedule 1, which gives, originally, there were Part 1, Part 2, Part 3 states. And Jammu and Kashmir finds place in Article 1 read with Schedule 1. So where was the question of all this confusion? On 26 January 1950, the day the Constitution of India is promulgated, as per the instrument of accession, Jammu and Kashmir was integral part of India. And the same declaration finds in the constitution of Jammu and Kashmir also. And that is precisely when this demand had occurred, Dr. Ambedkar refused to draft Article 370.
Right.
And it was Mr. Iyengar who was given a responsibility to draft Article 370, and this mess was created. God forbidden, whoever says whatever, as on today, Article 370 is a history.
Yeah.
And I don't want to go to comment on Pakistani journalist or Ms. Bhasin or whoever is saying whatever. But I have given my view, and slightly with full respect to Mr. Nariman, a slightly different view from Mr. Nariman. I think I have made the initial position very clear. Over to you, Mr. Bhatia, Brigadier Bhatia, if you have any questions and any comments.
That was very well explained. In fact, while preparing for this discussion, I've gone through a lot of material, but the way you have explained it was wonderful. Though most of it has been covered, I will just flash this thing. My question is, under the Constitution Order 272, why Article 367 was amended to read Legislative Assembly in place of Constitutional Assembly. You have alluded to this. Was it held unconstitutional by CGI? And invoking Article 373 itself to revoke and abrogate the entire 370 was within the executive powers of the president. However, such actions were subject to judicial and constitutional review. The judicial review was the Supreme Court judge itself and deemed no malignant intent on part of the president can be ascribed. Your little bit of comment, because this is actually not becoming very clear to most of us.
Okay, all right. Now, see, again, they as I had tried to clarify that the question was whether to take the path of Article 368 and amend the Constitution of India and go by that method. And there were hiccups and the problems and trouble there. There were definitely difficulties because of the lack of the majority, a two-third majority in the parliament. So what the path was taken was Article 367 method. Now, what the Supreme Court has held is that the amendment to Article 367 subclause 3 was unconstitutional, but we are not concerned much because there was an insertion of subclause 4 where the Supreme Court commented nothing. So that is the reason, despite that comment, it did not have much impact on the judgment. Had it been so unconstitutional, the result would have been different. So something which is, the Supreme Court is talking on a different point of view and saying that although it is immaterial, now even if you hold that subclause 3 or 367 3 was or 2 was unconstitutional, all right, if it is ultra virus to the powers of the parliament or unconstitutional method, and still if you hold that it does not have a bearing on this kind of decision, then who cares? Something a sideway is declared ultra virus or unconstitutional, all right. But ultimately, what all had an impact on this decision is considered to be constitutional and within the framework of the Constitution of India and within the power of the Constitution of India.
Absolutely.
I hope that gives
you absolutely clear. Absolutely clear.
Sure. Any other questions?
My next question. Then after this question, we'll take on questions from Janal Chaturvedi, sir, and then I will quickly go to the audience, sir. Neither China or Pakistan or the West will accept that the legal clarity of India's relationship with Kashmir are not open for any external interference or negotiation. Coupled with the growing comprehensive national power of India, how will this legal victory strengthen Indian government's hand that the institutions of India are in sync with each other? India can now take tougher stance while dealing with Pakistan and China on the issue of Kashmir. In fact, General Dushyant has also commented. I will just take on his question along with this, where he says, will this stand in ICJ if at all some domestic or international power decides to go to ICJ?
All right. May I answer?
Yes, please.
Now, before I answer, there is a chaupai in Ramayana, which is very apt to be quoted over here. दैट सेज समर्थ को नहीं दोष गुसाई। अगर आप सामर्थ्यवान हैं तो आप मुंह उठाकर इराक पर अटैक कर सकते हैं, सद्दाम हुसैन को बिना बात के गड्ढे में मार सकते हैं। अगर आप सामर्थ्यवान हैं तो आप पाकिस्तान की टेरिटरी में घुस के इस उसामा बिन लादेन को मार सकते हैं एंड नोबडी फ्राउंस। अगर आप सामर्थ हैं तो आप अफगानिस्तान में घुस जाइए, उनकी टेरिटरी ब्रीच कर लीजिए। तो ये तो बात सामर्थ्य की है। जब तक भारत में वो सामर्थ्य नहीं था, हम इसी बीच झूलते रहे कि यूएनओ का रेजोल्यूशन हो जाए, कि बायलैटरल हो जाए, कि ये हो जाए। कि जिस दिन सामर्थ्य आ गया हमने कर दिया, और वर्ल्ड में कहीं किसी पावर का आईब्रो भी फ्राउन नहीं हुआ।
yes.
तो आज की तारीख में पाकिस्तान तो शोर मचाएगा, वो मचा रहा है, बट वेयर डज इट स्टैंड? वो तो यूएनओ में तब से चिल्ला रहा है, आज भी चिल्ला रहा है, बट सी व्हाट इज हिज ओन एक्शन। यूएनओ रेजोल्यूशन इज ऑलरेडी डिफंक्ट, इट कैन नेवर हैपन, इट्स ऑलरेडी टाइम बाउंड। एंड हु एल्स, एंड हु आर चाइना एंड पाकिस्तान टू रेक अप दीज इश्यूज? चाइना हैज हिज ओन प्रॉब्लम। अगर चाइना इस बात को उठाएगा तो भारत आज उतना सामर्थ्यवान है कि तिब्बत के इशू को उठा सकता है।
Xinjiang, sir, Uyghur.
Yeah, because नहीं, even Tibet has been illegally occupied by China. तो ये तो देखिए सामर्थ्य पर डिपेंड करता। आज एक स्ट्रॉन्ग गवर्नमेंट इन अ स्ट्रॉन्ग पोजीशन, और अगर आप थोड़ा सा बैकग्राउंड में जाएं तो जो मेरी रीडिंग है मैं बता रहा हूं, यू ऑल मे डिफर फ्रॉम मी। जो फर्स्ट टर्म था इस गवर्नमेंट का, उसमें तो ये विदेशों में जा जाके फॉरेन रिलेशंस को इतना बढ़िया बनाते रहे कि यहां पर एक जोक चलता था कि भारत में कम रहते हैं हमारे प्रधानमंत्री, बाहर ज्यादा मिलते हैं। बट नोबडी अंडरस्टूड व्हाट इज ही डूइंग। और अगर किसी को यह लगता है कि ये जो कुछ मैंने आपको लीगैलिटी बताई, कॉन्स्टिट्यूशनल एस्पेक्ट ऑफ एब्रोगेशन ऑफ आर्टिकल 370, ये कोई ओवरनाइट हो गया या फर्स्ट टर्म और सेकंड टर्म में हो गया, तो ये भी एक भ्रम है। अगर आपको याद हो तो जो प्राइम मिनिस्टर भारत के आज हैं, वो 1990 में जाकर लाल चौक पर झंडा फहरा के आ गए थे। यानी तैयारी तो 1990 से थी कि पावर तो मिलने दो, हम एब्रोगेट करेंगे। मैनिफेस्टो में डिक्लेयर किया था। अगर आप मीन कैंप पढ़ें एडोल्फ हिटलर की, तो जो उसने किया उसने डिक्लेयर करके किया।
Absolutely.
तो ये तो वही बात है कि कोई आज नहीं, इनकी स्टडी तो 25-30 साल से हो रही थी कि इसको कैसे किया जाएगा। तो आज अगर लोग टेकन अबैक हैं कि माय गॉड ये कैसे हो गया, तो ये इसलिए टेकन अबैक हैं क्योंकि उनको ये नहीं पता कि इसकी तैयारी बहुत पहले से चल रही है। And that is why when Narsingh Rao, Prime Minister like Narsingh Rao can say that we can't abrogate this, उसके बाद हो गया और सुप्रीम कोर्ट उसको सैंक्टिटी दे रहा है, तो मेरा ये समझना है कि ये कोई ओवरनाइट नहीं हुआ है, बहुत स्टडी करके हुआ है। और अगर ऐसे ही मूर्खता में किया गया होता तो फिर तो
पकड़ा जाता सर कहीं पे।
हाँ, सुप्रीम कोर्ट से तो आपको रेटिफिकेशन नहीं मिलता जी।
Another very important thing, sir, of course, it's a given thing. As an army man, we are very happy that this has actually strengthened our position in the international forum also. और अगर हमारे इंस्टीट्यूशंस अगर ठीक से काम कर रहे हैं, दे आर इन सिंक विद ईच अदर, तो हमारी अपनी साख बहुत बढ़ती है। एंड हमारी गवर्नमेंट और हमारी फॉरेन पॉलिसी और फॉरेन ऑफिस को बहुत ज्यादा पावर मिलती है इससे।
दैट्स राइट।
Sir, I'll now request Jan Chaturvedi to please take on the if he has some questions, sir.
Firstly, Puneet, thanks a ton. Very well explained. 2-3 things I'll reinforce to say what you have said. One is, to my mind, the writing came on the wall when on 25th November 1949, Yuvraj Karan Singh said, he ceded all his powers to Indian constitution. So that, say, Indian state. So sovereignty was, that day, question of sovereignty from that day did not exist. So to my mind, using this 368 route would have flawed, and this is the best way when article the subclause 4 was added. So this is one thing which I'm sure it is quite all right. Now, my only point in this case is, and where, as far as Pakistan in any case has no locus standi, after they having firstly not honored the 1948 resolution of
Withdrawal of
ceasefire,
the
UN
troops.
resolution, which they have not done it. The second part, they have not done it, so there's no question of anything. Third thing is, all the members of parliament from J&K, they had been, right from 52 onwards, had been taking oath in the with the Constitution of India, not to the Constitution of J&K. So therefore,
right.
they are part of India from that time itself. So that is third part, which my part is. Only question, then another thing which I think is, which Solicitor General had said, because the question came that 357 invocation, where it said that state hood. So he says in reasonable time it will be done, and which Supreme Court has reinforced. My final thing in this case is that this constitution amendment will take place in the sense that again state would be formed once delimitation takes place in reasonable time. But what Justice Kaul has said, I think that is very valid, and that is that truth and reconciliation. Because that is where all the wounds would be kind of taken care of. So these are the things which I feel are very important. But Puneet, you may like to comment on how the UTs would be converted into states. That is what my point is.
Now, see, very important point you have raised. The only thing which I want to inform you is that even otherwise, by various constitution orders in the last 70 years, if you see, in 7th schedule of the Constitution of India, there are 3 lists: union list, state list, and concurrent list.
Concurrent list.
There are 97 entries into the union of list. Now, for your information, as good as 92 items of the union list were already applicable to Jammu and Kashmir.
Yes, correct. Yes.
And they had adopted it with the concurrence of the government of Jammu and Kashmir. So, more or less, it was already, out of 12 schedules, 7 were already applicable into Jammu and Kashmir. Election Commission of India had the in charge of the elections into Jammu and Kashmir. So everything was more or less under the control of the government of India. So those who are saying that this is illegally done and this cannot happen and all that, I mean, in 70 years, everything has happened. This kind of एक जिसको कहते हैं कि फॉर्मेलिटी थी कि 370 है, बस नाम के लिए उसको हटा दो, बात खत्म. लेकिन वो 370 जैसे ही हटा तो उससे बहुत सारी अच्छी चीजें भी जुड़ गई. रिजर्वेशंस हो गया, ये जो उनके 35A का, बिकॉज हम इस पूरे 370 में भूल गए कि 35A भी एब्रोगेट हो गया. करेक्ट. तो yes. उसके बाद उसमें सब भारत के नागरिकों को भी उसमें नागरिकता मिल गई. कमिंग बैक टू स्टेटहुड, अगर आप आर्टिकल 3 ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया पढ़ेंगे तो उसमें द प्रेसिडेंट ऑफ इंडिया with the recommendation of the Parliament of India has been given 5 powers under subclause 3, that they can increase, diminish, change the boundary, change the name of any territory, and they can form a new state. तो ये जो आर्टिकल 3 सबक्लॉज 3 है, इसमें पार्लियामेंट को पावर है, प्रेसिडेंट ऑफ इंडिया को डिक्लेयर करने की पावर है. यहां पर जो एक टेक्निकल चीज रेज की जा रही है कि जो आर्टिकल 3 सबक्लॉज 3 आप पढ़ेंगे उसमें ओरिजिनल स्टेट की टेरिटरी को काट के कम किया जा सकता है, बढ़ाया जा सकता है, नया स्टेट फॉर्म किया जा सकता है, इंक्रीज किया जा सकता है, डिमिनिश किया जा सकता है. एक बहुत हाइपर टेक्निकल पॉइंट जो रेज किया जा रहा है कि आप पूरे के पूरे स्टेट को यूनियन टेरिटरी कन्वर्ट नहीं कर सकते। इस वजह से सॉलिसिटर जनरल को कहना पड़ा कि भाई ये टेम्परेरीली किया गया है, वी विल रिस्टोर द स्टेटहुड टू जम्मू एंड कश्मीर, बट द पोर्शन कट ऑफ फ्रॉम जम्मू एंड कश्मीर ऑफ लद्दाख विच हैज बीन डिक्लेयर्ड यूनियन टेरिटरी शैल रिमेन यूनियन टेरिटरी। एंड इनिशियली अभी तो मुझे लगता है जब स्टेटहुड वाली बात भी हो रही है तो मेरा जहां तक ओपिनियन है कि ये भी ग्रेजुअली होगा, क्योंकि अभी वो यूनियन टेरिटरी विद लेजिस्लेटिव असेंबली बनाए, शायद हो सकता है जम्मू एंड कश्मीर को, और लद्दाख को यूनियन टेरिटरी विदाउट लेजिस्लेटिव असेंबली बनाए, और जेएनके में यूनियन टेरिटरी विद लेजिस्लेटिव असेंबली बनाकर जैसे दिल्ली है, पौंडीचेरी है, इलेक्शंस करा सकते हैं। देयर इज अ पॉसिबिलिटी। सो रेस्टोरेशन ऑफ स्टेटहुड इंस्टेंटली पॉसिबल है, मैं कह नहीं सकता, बट मेरी एक ये दूसरा भी एक पॉसिबिलिटी है कि दे कैन फर्स्ट मेक इट अ यूनियन टेरिटरी विद लेजिस्लेटिव असेंबली और इलेक्शन करा देंगे, बिकॉज सुप्रीम कोर्ट सेज इलेक्शन कराइए
September 24.
हाँ, तो हो जाएगा। सो दैट स्टेटहुड जो आपका क्वेश्चन था, दैट कैन बी डन अंडर आर्टिकल 3।
Mr. Punit, there is a question from the audience. So, in the same vein, I'll take it. It was on the same subject. So, that's why I have interfered. Ask, our country is an indestructible union of destructible states. Many states have been carved out of larger states. Why are people crying over temporary conversion of J&K to union territory via parliamentary assent?
Very good question. Who asked this?
This is Shritik Kothari, sir, our regular audience.
Oh, Mr. Kothari, very well, very well. I'm happy that you raised the right point, because since the beginning of the State Reorganization Act of 1956, we have been making states after states after states. और 2000 में हमने 3 स्टेट्स बनाए, उत्तराखंड, झारखंड और छत्तीसगढ़। उसके बाद रिसेंटली हमने तेलंगाना बना दिया आंध्र प्रदेश को काट के। तो ये प्रोसेस चलता है, लेकिन यहाँ पर जो आपने क्वेश्चन पूछा है कि क्यों इतना शोर मच रहा है जम्मू एंड कश्मीर के कन्वर्जन को लेकर, तो वो इसलिए मच रहा है, जैसा मैंने अभी बताया, कि जम्मू एंड कश्मीर को स्टेटहुड से यूनियन टेरिटरी में कन्वर्ट कर दिया गया है, जो अभी तक नहीं हुआ है कहीं। मतलब यूनियन टेरिटरीज को स्टेट बनाया गया है। गोवा को आपने स्टेट बना दिया, दिल्ली को आपने यूनियन टेरिटरी विद लेजिस्लेटिव असेंबली बना दिया। ऑल टुगेदर स्टेट को यूनियन टेरिटरी रिवर्स नहीं किया गया था अभी तक, इसलिए थोड़ा शोर मच रहा है। बट ठीक है, ये तो डेमोक्रेसी है, सबके अपने अपने शोर मचाने के हक है जी। I hope that answers Mr. Kothari's question. Any other question?
Yeah, there are many. In fact, I'll have to select.
Please.
This abolishing the J&K constitution also dissolves the Ranveer Penal Code. Will the IPC now override all difference between the two penal code? This is asked by Rishi Atre.
Rishi, that's right, but बहुत जल्दी, मतलब कल लोकसभा में पास हो गया, अब तो आईपीसी भी नहीं रह रहा है, अब तो आईपीसी भी जा रहा है, तो
बीएनएस
हाँ, मतलब भारतीय न्याय संहिता आ रहा है। और टू आंसर योर क्वेश्चन, यस, अब भारतीय न्याय संहिता पूरे भारत के कोने कोने तक अप्लाई होगा, इंक्लूडिंग जम्मू एंड कश्मीर। रणबीर पिनल कोड इज अ हिस्ट्री, दैट्स फॉर श्योर। And by the way, आपकी सिर्फ जानकारी के लिए बता दूं कि I had a fortune to appear before Jammu and Kashmir High Court, and I had also argued some matters on Ranbir Penal Code also. It was more or less on the line of IPC, not much difference.
Okay, so okay. I will. There is, in fact, most of the questions you have already answered. I will just see if I can get some. In fact, there is some sort of conversation which is going on amongst the audience. So I have to select. I have to select the first one. Where did this conversation start?
As
Okay, there's just a
Puneet,
very small comment. JB, again, one of our, he has asked you why was the word maverick used? In the introduction you had said.
Because, see, everybody has its opinion. I have my opinion. Mr. Fali Nariman is saying it's bad in law. I'm saying it's a maverick activity of the government of India. That's it. I mean, I've chosen the word maverick, or I have chosen the word legislative wizardry. So these are my words, and I stand responsible for it. You can openly criticize me. That's not a problem.
no, but I think the way you have explained it is very interesting to
Yes.
note that the constitutionality of the existing law has been very innovatively used to.
That's precisely I use the word maverick.
No, I'll just clarify, Mr. Punit. This comment of our audience, he's a regular one, was immediately moment you mentioned. I'm sure
Okay.
moment you explained it. After that, he's not said.
No, but then most welcome. This is
I
democratic
saw some
country.
comment of the Dushyant. Just can you go back to Dushyant's point?
I'm just putting it on. Another question by General Dushyant sir: can this be reversed in future by a future government?
If they have this maverick officer, anything is possible. General Dushyant, anything is possible in the Constitution of India, and but that will be highly unlikely. But if they are also maverick, they can do it.
No,
Going
but
back,
Puneet, as I can see, it can be done only by constitutional amendment.
That's
There
what
is
I'm
no
saying.
other way which can.
That's what I'm saying. I'm just answering the
If
Lieutenant
someone
Dushyant
gets
Singh.
400 majority in Lok Sabha.
No. As I had, while my inaugural comments, I had stated that the Constitution is a living document, unlike a religious scripture.
Text.
So anything is possible. So his question that can it be done? Yes, of course it can be done, provided you have those kind of mavericks in the new government, in the future government. And as far as the likelihood of this is concerned, I don't think so, because it's highly unlikely that this can be undone. Because if anybody tries to undo it, it will be fatal. And like, for example, the just for analogy, Lieutenant General Dushyant Singh, for your to give an analogy to this aspect, that initially the reservation was included into the Constitution of India for first 10 years and only into the legislative assemblies and parliament elections. Later on, it was extended to education and services as well. And today the situation is that every government keeps on increasing the reservation. Nobody even bothers to reverse it, because reversing it will be fatal to them. So, howsoever, in the same way, I don't think any government will ever dare to reverse this, which has been done. But if your question is, can it be done? Yes, it can be done by the constitutional amendment, as it has been readily, by my only statement itself, I had said that Constitution can be amended anytime.
I'll give a mathematical analogy to it. There is a
Yeah.
law in mathematics, Poisson's law, which says possibility is there as per that, but probability is not there.
That's not there. Very well said. Very well
sir,
said.
the way politics is going around, managing a 2/3 majority is
Highly
question.
unlikely. Highly unlikely. And even
Oh,
if
in
you
both the
have two-third,
houses. In
and
both the
even if you
houses.
have two-third majority, I don't think any leader in the right mind will be doing undoing this abrogation, because it is not in the national interest.
That is one, sir, and it is also will be a political suicide for that party, sir.
That's
And
What will it
that's
gain?
no. Puneet, one thing which I would like to say, that 2/3 majority, not only in Lok Sabha, It is
In-
2/3 majority in Rajya Sabha, which
Both
will take
also.
another 5 years to come post that.
And
By the time probably Lok Sabha
and
majority would
no,
go.
no, no. Plus one more thing, more than 50% of the states concurring.
Correct.
Yes. So it is, as I said, the probability is not there.
The probability is not there, and even possibility is highly unlikely. But the question was, can it be done? Yes, because Constitution is a living document. It can be done. G, any other question?
Sir, I think we have covered a lot of grounds, and with your permission, Jan Chaturvedi sir, I think we can now conclude this session, sir.
Yes, I think very all it is left, I think, which you would be doing. Thanks to the speaker, he has, I think, covered it very well and very cogently and lucidly. He has explained the legal aspect. Political and geopolitical issues we have already discussed during our last discussion.
Sir, I take this opportunity to thank Mr. Punit Chaturvedi for coming over. Now, going by his biodata, I think we'll have to request you to come more often on our channel, sir.
That will be an honor. That will be definitely an honor, and I'm more than willing to address such an august gathering with such elucidated and erudite people. It will definitely be an honor.
Thank you very much, sir.
You need not to request. You can just pass on a command. you all are more habitual of issuing commands, and I am just your legal soldier from the point of law.
Thank you very much, sir. This is one subject which needed clarification and detailed. You've explained it with a lot of patience. Like I mentioned earlier, while preparing, I was totally confused. To some extent, my reading helped, but now I'm absolutely clear about the legal status of Article 370, plus many other things also. Thank you very much, Mr. Punit Chaturvedi, sir.
And I regret that my camera did not work, but I can see all the handsome faces of all of you. Thank you so much.
We will make sure that next time everything is in place.
That's right. Thank you so much.
Thank you, sir. Thank you very much, sir.
My pleasure.